The I-140 petition is approved. What happens next? That's what we're talking about today. My name is Emily Sumner with Sumner Immigration Law, and this video is designed for HR professionals or managers, foreign national workers in the United States going through the employment-based green card process, and anyone else who supports the immigration strategy within an organization. So again, today we're talking about what happens after the I-140 petition is approved. So before we go any further, let's talk about what the I-140 petition is. Generally speaking, the I-140 petition is the second step in the employment-based green card process. Now, when I'm talking about the employment-based green card process, in this context, I'm talking about the PERM labor certification-based process. So the first step in the process is the PERM labor certification application. Once that is certified, then we file the I-140 petition, or the employer files it. We prepare it, the employer signs it, we file it. The I-140 petition is the second step. And then finally, the I-485 application for permanent residence, or in some cases applying for the immigrant visa overseas, is the third and final step in the process. So this information that we're talking about today, what happens once the I-140 petition is approved, really is mostly going to pertain to that particular process. If you are an individual that has an I-140 petition that you filed on your own that was self-sponsored, so a national interest waiver petition, or perhaps an EB-1A for foreign nationals of extraordinary ability, some of this information will be relevant, but not all of it. As always, this information is for informational and educational purposes only and is not legal advice. So what are some common questions and missteps once an I-140 petition is approved? It is an exciting time, right? It feels really good because it's been a long road getting that labor certification application prepared and then filed, waiting a long time, and then finally having it certified. And then getting that I-140 petition submitted and having that approved feels really good, and it feels really great to be that far along in the green card process. And you absolutely should celebrate it, but there's some things that you absolutely should be aware of as well, so you don't take a misstep and perhaps jeopardize your immigration future or that of your foreign national employees. So one question that comes up a lot is, can I switch jobs? Once I have the I-140 petition approved, can I switch to another job? The answer is yes, but. So yes, a person absolutely can. However, if you have not filed the I-485 application, and remember, you can't do that until the priority date is current. So a lot of times employers or employees rather are not able to file the I-485 application right away. So if you haven't filed the I-485, you're going to have to start the employment-based green card process over again with the new employer. That's also something to keep in mind if you are an employer or HR manager, HR professional, that if you hire someone who has an I-140 petition approved, that's great. There are benefits to that they can take advantage of, even though the labor certification was filed with a different employer. But unless they have filed the I-485 and they're at a certain point in that process, you will have to file the PERM labor certification process all over again for them if you want to sponsor them for a green card. You don't have to sponsor them for a green card, and we'll talk about that later. But the bottom line is, yes, you can change positions if you have the I-140 petition approved, but know that that new employer will have to start the process over again for you. The exception there is if you plan to return to the original employer. So let's say that employer A files the PERM labor certification, you have the I-140 petition approved. That's amazing. Once you have the I-140 petition approved, you can use that priority date for subsequent green card application filings. Okay, so if you move from employer A to employer B, you start the green card process over again with employer B. You can retain the priority date from that first filing with certain exceptions, narrow exceptions, but you can retain the priority date from that first filing and apply it when you submit the I-1, or your employer submits the I-140 petition through employer B. So that's a good advantage, a great advantage. Another advantage is you can use that I-140 approval to extend your H-1B status, if you are in H-1B status, to extend the H-1B status beyond the 6th year if you need to. Again, there's certain exceptions that the I-140 petition can't have been revoked or withdrawn within a certain time frame, so make sure you're paying attention to that. But in general, you can extend the H-1B status beyond the 6th year. What if your priority date is not current yet? What do you do? Do you just wait? The answer is generally yes, right? You generally do have to wait for the priority date to become current before you can file the I-485, and that can be a long wait. If your priority date is not current yet, you absolutely need to maintain status, whatever status you hold, whether that's H-1B, L, whatever status, whatever classification you hold. Just having the I-140 petition itself approved does not give you status, immigration status in the US. It doesn't allow you to work here, it doesn't allow you to stay here. So if your priority date is not current yet, then you need to maintain status. You need to keep an eye on that visa bulletin and know what your priority date is and make sure that you're tracking it for when it becomes current. And we'll talk about some other tips related to that in just a few minutes. What if there is a layoff and you have the I-140 petition approved, but you are laid off, unfortunately, from your company? Same idea as changing jobs. First of all, I'm sorry for anybody that happens to. That's a very stressful situation. But the idea is the same as if you were changing jobs voluntarily, right? So you would ideally find a new employer. That new employer, you would have the advantages of, if you meet the requirements of being able to keep that rate, retain that priority date, and being able to extend beyond the 6th year using that approved I-140 petition. But the new employer would need to start the green card process over again. I started saying this a few minutes ago and didn't finish it, but if you, let's say employer A files the perm labor certification for you and you change jobs, then like I said, generally speaking, employer B has to start that process over again for you. You can't, if you have not filed the I-485, you can't transfer that process over. You can keep those benefits, the retaining the priority date and extending beyond the 6th year, but you can't transfer that labor certification to a new employer. However, if you plan to return to the original employer as of the time that you receive the green card, you can, at least in theory, do that and still submit the I-485 based on that original employment when the priority date becomes current. That's not a common situation, especially when it takes so long for the priority date to become current, but I've had clients who have done this before. It has to be truthful. You do have to plan to return to that employer and they have to have, agree to that when you receive the green card, but it is possible to work for other employers in the meantime. So what are some compliance tips? If you have this I-140 petition approved, whether you are an employer, HR manager, HR professional, or a foreign national employee, what do you do in the meantime once that I-140 petition is approved? Like I said, you absolutely want to make sure that the foreign national is maintaining status, their underlying status, whether that's H-1B, L, TN, whatever it is, in the United States. If you change jobs, have a plan. If you are a foreign national and you change jobs, have a plan to the extent possible. If it's a layoff situation, you may not have a lot of control over the situation, but make sure that you have a plan, if not immediately, then at least medium or shorter term, for making sure that you have a basis to file the I-485 down the road. Same thing if you are an employer and you are hiring someone who has an I-140 petition approved. That's great in the sense that they can extend the H-1B status, again, if they have H-1B status beyond the 6th year. But you as the employer and the foreign national, nobody wants to be in a situation where the priority date is current and you don't have a valid perm labor certification that supports filing that I-485. In other words, the foreign national would either need to plan to go back to the original employer, which may or may not be feasible, likely not feasible. And by the way, that original employer would also have to confirm that in writing through submitting the I-485J supplement. But they would either have to return to the original employer or they would have to have that perm labor certification in place, certified, already done, which takes at this point at least a couple of years to get through that process before they are able to submit the I-485. And I know it seems like, and a lot of times it seems like, oh, the priority date is years and years and years away. That may be true, but sometimes it does sneak up on you and you do not want to be in a situation where the foreign national worker is able, their priority date is current and they would be able to submit the I-485, but the employer hasn't submitted the perm. They haven't started that process and they're not able to support their employee. That is not a good situation, not a situation you want to be in if it's at all possible to avoid that. So if you're the employer, think about strategically, intentionally about when, whether, and when you are willing and able to start that green card process, the perm process, even if they have an I-140 petition already approved. And likewise, if you are an employee with an I-140 petition approved from employer A, don't assume that you're good to go and you can submit the I-485 down the road. You have to have the underlying perm to support that. Make sure the final tip in terms of compliance is make sure to notify your lawyer, whether you are the employer or the employee. Make sure that the immigration lawyer knows proactively ahead of time of any significant changes in the employment. So that means if you're being promoted, if your job duties are changing, if there's a change in the location, if the company moves from location A to location B, especially if it's going to be far away. But again, please check with us because we're able to advise on these things proactively and help you come up with a plan. But it's really hard to do when we find out 2, 3, 4, 5, 10 years later. Another reason that you would want to notify the immigration lawyer is if there's a change in the company ownership. So make sure that you're communicating. We will help you come up with a plan. But we can't do that if we don't know what changes are happening. And then planning ahead. So like I said, it feels really great. It's exciting to have the I-140 petition approved, and absolutely that's something to be celebrated. It is a milestone in the process, and it's a moment to, celebrate for sure, but also to plan ahead and to make sure that you're ready for that third and final step when it does come. So that means tracking the visa bulletin. That means making sure that you know when your priority date is, what your priority date is, and knowing when you're eligible to file. It means understanding portability, green card portability. So we have a video on this in Sumner School Business Immigration Basics on our YouTube channel. So check that out if you're not familiar with green card portability, or if you just want to make sure that you have a clear understanding of it. But the short version is that you can change employers. I've spent this whole video so far saying if you change employers, you have to file a new labor certification, and that's generally true. But if you, as a foreign national worker, have filed the I-485 already, if it's been pending at least 180 days or longer, if you have the I-140 petition approved or it's approvable, and if you're moving to the same or similar employment, you should be able to port that green card process to a new employer. So make sure you have a clear understanding there and a clear strategy in place if that's something you decide to do. And make sure that you understand what's going on. Make sure that you are keeping track of the changes in immigration law. I know it's a lot to keep up with. And then final point is have your documents ready. So there are certain documents that you're always going to need for an I-485 filing. That includes things like copies of your immigration documentation. If you have any criminal charges, even if they've been dismissed or expunged, and that can include traffic tickets, citations, traffic citations. Have that documentation with you. Copies of your birth certificate, marriage certificate, divorce decrees, your children's birth certificates, things like that. Have a file, a centralized file with that documentation. So as soon as that priority date is current, you're able to send it off to your immigration lawyer and have things prepared quickly. So I hope that you have found this information helpful about what to do, considerations, tips, and next steps once the I-140 petition is approved. If you found this information helpful, I hope that you will share this video with a family member or a friend or a colleague, and make sure that you are subscribed to this channel. Until next time, I'm Emily Sumner with Sumner Immigration Law. We're helping clients around the world and here in the United States, all over the United States, regardless of location, with family-based and employment-based immigration matters. Until next time.